Attorney General R Venkataramani informed the Supreme Court that Article 370 was incorporated into the Indian Constitution to address a complex situation in Jammu and Kashmir between 1947 and 1950, induced by external factors. He also asserted that it should have been revoked in 1957, immediately following the dissolution of the Jammu and Kashmir Constituent Assembly. Does the Supreme Court have mathematically sound constitutional formula to resolve a political situation that prevailed in the state and a similar constitutionally crafted solution to the decades of disturbance resulting in loss of lives in the erstwhile state? The AG asked a bench of Chief Justice Chandrachud and Justices S.K. Paul, Sanjeev Khanna, B.R. Gawai and Surya Kant. AG emphasized that Jammu and Kashmir, ever since its signing of the Instrument of Accession in October 1947, marking its full integration into India, has constituted a broader context. He urged the court to consider the historical, current and substantial future implications when assessing the validity of the decision to abolish the contentious elements of Article 370. Because of the external aspects of situation prevailing in the state, the farmers of the constitution had provided for Article 370 with a dual intent: to tide over the situation and provide gradual constitutional integration of Jammu and Kashmir with India. The AG said and asked, can the Supreme Court lay down judicially measurable standards for a political decision to abrogate the provisions which stood in the way of Jammu and Kashmir's complete integration within India? Appearing for petitioners in support of the centre's decision, senior advocates and constitutional experts Harish Salve and Rakesh Dwivedi said the constitution farmers arrived at a compromise in the shape of Article 370 to balance competing views, with Congress and Sardar Patel opposing special status of Jammu and Kashmir and others calling for complete autonomy, including plebiscite. Salve said, it may be difficult to find a legal logic in the way Article 370 is uniquely framed because it was a political compromise. The interpretation of the Instrument of Accession, which completed the physical integration of Jammu and Kashmir in India, is a sovereign act and not open for judicial analysis. Relying on the doctrine of impossibility, Salve said Article 370 Clause 3, which provides for a mechanism for self-extinction, has been rendered impossible to be followed after the dissolution of the Constituent Assembly of Jammu and Kashmir. Once the Constituent Assembly ceased to exist, the President had suo motu power to abrogate the article. He said, the AG agreed and said despite this suo motu power, the President preferred to adopt a mechanism that was closest to the prescribed constitutional process while taking the decision on August 5, 2019. The AG agreed and said, despite this suo motu power, the President preferred to adopt a mechanism that was closest to the prescribed constitutional process while taking the decision on August 5, 2019. Rakesh Dwivedi, appearing for petitioner Ashwini Upadhyay, said Article 370 was the expression of an emotion of people that was respected at the time of Jammu and Kashmir's integration by the farmers of Constitution. As human beings and as nation, we all must get over the emotions and work towards building the nation as a single entity without any discrimination towards citizens based on their place of residence. A Times Online report.
From breaking news, detailed analysis, in-depth interviews and explainers, follow the Times of India. Subscribe to our YouTube channel. Don't forget to like our videos and hit the bell icon to stay updated with the latest.